in the matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, Counselor, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
What? This is what he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get this.
All right, folks, buckle up, because what you're about to witness is a courtroom clash that's equal parts absurd and unbelievable. At the center of it all, Joshua Lanto, a man who believes he's uncovered some grand legal loophole, yet can't seem to grasp the basics of court procedure. Now, this isn't just another day in traffic court. This is a sovereign citizen spectacle, complete with demands for non-existent proof of jurisdiction and claims so bizarre they border on comedy. But here's the catch. While we might laugh at the antics, this case raises real questions about how far courts will bend before snapping. We've got a defendant convinced the judge owes him documents that don't exist, an attorney trying to hold things together, and a judge who, spoiler alert, has the patience of a saint. As we break this down, I want you to pay close attention to the contradictions, the emotional outbursts, and the moments where the judge clearly sees through the nonsense. And stick around until the end, because this showdown takes a turn that perfectly captures the tension between stubborn defiance and judicial authority. Ready? Let's dive in.
You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they sent me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial?
Here it is, the official start. The judge calls the case of People versus Joshua Lanto. Now, for those unfamiliar, this is where things should get simple. The court confirms appearances, sets the stage, and moves forward. But with Lanto, nothing is simple. Notice how even before the hearing properly begins, there's already confusion. Counsel leaves the room, the judge waits, and Lanto is sitting there ready to pounce. This kind of chaos, right at the start, isn't just procedural noise. It's a foreshadowing of the circus that's about to unfold. And it raises a key question. Is this disorganization part of the defendant's strategy, or just his inability to follow along?
Has to say, but first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney. Okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say? Can you?
I haven't sent this to the assignment clerk, Mr. Lanto. You're not listening.
Here's our first taste of sovereign citizen logic. The court is simply trying to grant a routine 30-day extension for discovery. Pretty standard stuff. But Lanto jumps in with, why don't we just drop this right now? Think about the mindset here. In his world, a case can vanish if he just refuses to play along. But law doesn't work like that. You can't opt out of criminal proceedings like a subscription service. This is classic sovereign citizen behavior, pretending the court has no authority unless it produces some mythical jurisdiction proof. It's dramatic, it's disruptive, And it shows us exactly how detached from reality he is.
See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No, you're all set.
It seems like you were
Leave the
getting
meeting.
angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts and nobody has said I'm talking.
Boom. There it is. The judge's patience starts to crack. You're talking crazy. That's not just courtroom banter. That's a judge signaling that the arguments being made have no grounding in law or fact. And honestly, you don't often hear judges use plain language like that. Normally, they keep things formal, calm, and precise. But here, the nonsense is piled so high that the judge breaks character and calls it exactly what it is. For viewers, this is a turning point. It's where the courtroom transforms from legal process into open conflict.
Reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And then number two,
we're asking for discovery.
okay, and then the proof of jurisdiction is going to be in there? Is that, I'm asking a simple logical question. It's either yes or no, the proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
Well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
well, I feel like I'd be in danger if I.
This moment right here is fascinating. After being told he's talking crazy, Lanto flips and says, "No, you're awesome." Classic deflection. Instead of directly addressing the legal reality, he tries to charm his way out, or maybe mock the judge in a sarcastic tone. But make no mistake, this isn't flattery. It's a power play. By refusing to take the judge seriously, he's trying to undermine the authority of the entire courtroom. And that's dangerous, because courts rely on respect and order to function. Without it, hearings turn into, well, exactly what we're watching.
You won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
would
thing
you
I could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me? And then you said I'm talking crazy.
No, you got it.
Did I just recall what was said on the record? Did I just recall that correctly?
No, you said it in reverse. I said first that you're talking some crazy talk. Then I said I'm going to adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days.
Notice how Lanto keeps circling back to jurisdiction. This is the hallmark of sovereign citizen rhetoric. Demand proof of something the court isn't legally required to provide, then claim victory when it doesn't magically appear. But here's the irony. Lanto admits he'd be willing to plead guilty if only the judge gave him that proof. So what's really going on? Is he trying to expose some grand legal truth or just looking for an escape hatch from accountability? Either way, his logic doesn't hold up. Courts have jurisdiction by statute, not by producing a one-page document to appease conspiracy theories.